welcome to today's webinar presented by EQS Group together with our partners from KPMG Law. Welcome everyone. We are going to talk about the EU Whistleblowing Directive today and the transposition status that we've currently reached among the member states. So during this webinar and the next 90 minutes, we will try to give you a good overview on where we are, where different countries are or not yet aren't, probably. So we'll hear more about that from the speakers that we have on this webinar today. By the way, speakers, so it's really a pleasure to have a large group of speakers and experts from KPMG in this webinar that will shed further light on implementation and transposition status in different countries and gives a general overview. Every one of them will do a short introduction in her or his part, speaking later on during the webinar. Overall, it will take roughly 90 minutes that we're trying to fill here. Maybe upfront apologies if we should be running into smaller technical issues. It's a large group of speakers, so we never had so many speakers in any webinar before, but we are confident that we will make it. And as you will see, some of the speakers will just be able to hear. They cannot share the camera, unfortunately, so we could not solve this upfront. Don't be surprised, it's not a bug. We know that this is the case, but in the end, I'm sure it's much more important that you hear about the content, about the subject of this webinar. My name is Jens Bressler at EQS Group. I'm responsible for business development activities around our compliance cockpit product and solutions. I'm in and around compliance and different functions since 15 years, and I will host this webinar today from the EQS side and do the moderation and take you through it. Some small logistics maybe. So you will not be able to, as a participant, to ask questions using the microphone, but we are happy if you ask any questions using the chat function. There will be a Q&A session at the end of the webinar, and we are happy to take your questions. Please feel free to post them, and we will try to then get them answered for you if possible. If you require support, as you can see here, find the question mark, click on it, and my dear colleagues in the background will be happy to support you if possible. And I think that's more or less it at this stage. So before I hand over to Bernd Federmann from KPMG, let's probably start involving you by asking the first question to get us going. So you should now be able to see it and to answer it. So the question that we would like to ask all of you is, what is the status of the implementation of the Whistleblower Directive in your company or organization? So for answer options, we would highly appreciate if you participate, give your answers now, and then we can look at the results and take it from there. So we'll give this a short moment so I can see the first ones already answering. So we'll wait a few more seconds. So we are nearly at 50% of all participants, but still people participating. So wait. Right. With regards to the time, and as we already have a really significant number of others, I will just close the poll question now, and we can now take a look at the results, and then I will hand over. So interesting to see that nearly half of the people that participated in this question are more or less saying we already have a whistleblowing system in place and it's meeting the requirements of the directive. So fingers crossed, and I hope for all those who chose this answer that this can be confirmed during the webinar. So when you hear about the details and the requirements, that this confirms your estimation. Interesting enough, let's say the other half is in different stages of not entirely sure if meeting all requirements already, or not even having a whistleblowing system in place, so anywhere in between. So I think what we can see is this is not 99-1% split, it's maybe half, and it makes perfect sense to discuss this further and get a better picture on where we are. So by saying this, I would like to hand over. It's really a pleasure to welcome Dr. Bernd Federmann from KPMG Law. He's a partner and the head of compliance and corporate criminal law in KPMG Law Germany. And yeah, Bernd, would you like to take over here with the results of this poll? And yeah, happy to hear your opinion, your thoughts, and take it from there. Thank you.
Yeah, many thanks. Then yeah, let's go to the next slide. The next slide. And yeah, also welcome to the audience from KPMG. My name, Bernd Federmann, partner with KPMG Law in Germany, with focus on compliance advice. Today, the colleagues of the KPMG Integrity Service Network want to give you an overview over the current status of transposition of the directive into national law throughout the 27 member states. The KPMG Integrity Service is a global network of more than 70 independent KPMG country offices specialized on legal and forensic advice on all topics around whistleblowing, together with our alliance partner EQS Group. We can go to the next slide, please. The EU directive on the protection of whistleblowers requires all organizations with more than 50 employees on the law, as well as the public sector, to set up internal reporting channels and case management systems to report and process violations, especially of European law. Here you can see the agenda of today's webcast. The EU Whistleblowing Directive is expected to be largely implemented in the European member states in the course of 2022. Ariane Loof and Andreas Brucksch will give a high-level overview over the situation in all member states, where the directive is already transposed, where it exists a draft law, and where nothing has happened so far. Then we will have some deep dives into the situation of Austria, done by Susanne Flöckner, Denmark, done by Christian Berger-Larsen, Finland, done by Antti Alto, France, done by Julie Belson, and Sweden, done by Michelle Johnson. At the end, EQS will present the system which is technically able to cover all these legal requirements. The colleagues, as said before, will each shortly present themselves when starting their contributions. The presentation will, after the webcast, be sent to you upon request. We can go to the next slide, please. The status of transposition of the EU Whistleblowing Directive varies across the EU member states. The status is here seen as of March 22 on the map. Yeah, we've also prepared a white paper with regard to the details which can be downloaded on our website. However, the details of the member states' situation are now outlined by my colleagues in this webcast. And At this stage, I'm happy to hand over to Andreas Brucksch and Ariane Loof. Thank you.
Thank you very much. My name is Andreas Brucksch from KPMG Law in Germany. I am an employment law expert, and I'm currently involved in many projects to implement whistleblower systems in companies and in groups. In the next few minutes, my colleague Ariane Loof and I will give you, as Mr. Federmann has already mentioned, a brief overview of the implementation status of the EU countries, which our colleagues will not go into in detail at a later stage. We will start with the few countries that have already implemented the EU Directive. So we can go to the next slide, please. Yes, in Cyprus, the directive was transposed into national law in February this year. In addition to the reporting topics of the directive, this law also provides for further reporting topics such as criminal offenses, including corruption, non-compliance with any legal obligation, violations imposing danger to security or health of a person. Anonymous reporting of violations and reporting by email are permitted. And for companies with 50 to 249 employees, the law does not have to be implemented until December next year. The penalty for violations is up to 30,000 euros. Denmark and France have also already transposed the directive. My colleagues will go into more detail on this later. So we can go to the next slide, please.
So, and I will take over Latvia. Hello, I'm Ariane Loof, a lawyer on data protection law and labor law based in Berlin and working for KPMG Law. So I will give a short introduction into the implementation status, transposition status in Latvia. Latvia has already transposed the whistleblowing directive to national law, and the new law is in force since 4th February this year. The transposition law largely follows the directive. However, the law provides some additional topics as violation of national law and criminal offenses. The anonymous reporting is not prohibited, which means it is not mentioned whether it's permitted or not in the law, so it is not prohibited. But however, anonymous reporting persons are not protected by the law against retaliation measures, and they are not entitled to investigation measures. The whistleblower, so companies under 50 employees can share internal reporting channels, and the fine for any violation amounts up to 7,000 euros.
So let's go to Lithuania. In Lithuania, the directive was also transposed in February this year. In addition to the reporting topics of the directive, any violation of the law in public interest can also be reported. A special feature is that private legal entities with less than 50 employees must implement internal reporting channels if their activities relate in particular to consumer and investor protection, or to the financial and insurance sector, to the transport sector, or to the environmental protection. The anonymous reporting in Lithuania and the reporting of hints via email is also allowed. So we can go to the next slide, please.
Then we come to Malta. Malta has also already transposed the directive to national law on 18th December last year, so it's already in force. The law provides as well for additional topics such as violation of national law, which includes criminal offenses, The anonymous reporting is not prohibited as well, and it's the same as Latvia. Anonymous reporting persons are not protected by law. The email reporting is not prohibited, as we can see for other countries. In some countries, the email reporting is not permitted, but here the email reporting is not prohibited, so it's allowed. The whistleblower protection, the whistleblower are protected against retaliation measures. But we have a special measure for reporting employees in Malta. The reporting employees in Malta are entitled to receive support by facilitators, so the companies need to install such a gremium or such a person, need to assign some facilitator who supports employee on request. So and then we come to Portugal.
Yes, and in Portugal, the law was transposed in December last year. However, it will not enter into force until the 18th June of this year. In addition to the reporting topics of the directive, violent and severely violent criminality, organized crime, and economic and financial crime are additional reporting topics. Fines for violation may reach up to 250,000 euros. Sweden has also already transposed the directive, and my colleagues will go into more detail on this at a later stage. So we can go to the next slide, please.
So I take over for Austria. Only announcing the later report presentation by our colleague from Austria. The next law, Belgium, we'll go with a short introduction. Belgium has not yet implemented the directive, but however, a preliminary draft has been published already in July last year. The parliament vote is expected in July this year, and it will get into force, the law expected 2 months later, so mid to late September this year. The draft law provides additional topics to be reported as tax fraud and social fraud. Anonymous reporting will be permitted under the expected new law. Small businesses are expected to have a later implementation date for the whistleblowing system, which is the 7th December in 2023, next year. Belgium has some special measure for victims. Victims are protected by a federal agency. They are encouraged to submit their report or a complaint also to the federal coordinator, which will then care for protection, whistleblower protection by the company. The fine for any violation will be up to 5% of the annual turnover, and natural persons will be fined with imprisonment up to 3 years or up to 6,000 euros. Then we come to Bulgaria.
The next slide, please. In Croatia, a local whistleblowing act already applies, which remains applicable until the new law is in force. Croatia is expected to transpose the directive by the end of March this year, and will be one of the next countries which transpose this law or this directive. The declaration of anonymous hints shall be permitted in the same way as the declaration by email. Penalties for violation amount to approximately 4,000 euros for legal entities.
Then we come to Estonia. Estonia has not yet transposed the whistleblowing directive, but has a preliminary draft published, and this has already passed the Parliament's first vote in January this year. The transposition is expected in June 2022. The law will provide further topics to be reported: violation of national law, if this law is not subject to sectoral restrictions. What is the speciality of Estonia is the reporting of state secrets will not be allowed. So there will be an issue how to define state secrets and how to prevent any reporting of this. The anonymous reporting will be permitted, as well as email reporting. Small businesses up to 249 employees will have the chance to will be obliged to implement the whistleblowing system until 17th December 2023, so have more, a bit more time. The fine for any violation will amount up to 400,000 euros, which is quite high, and for natural persons up to 1,200 euros. And then we can go to the next slide, please. Finland has not yet implemented has not yet transposed the whistleblowing directive to national law, but however has a draft law, which will be explained by our colleague afterwards in detail.
And Ireland, a draft bill was published in February this year. The transposition is expected in the second quarter of this year. The violation of competition law, state aid law, tax law, and public procurement law should be additional reporting topics. Anonymous reporting should not be prohibited, and companies with 50 to 249 employees will not have to implement a whistleblowing system until December next year. The penalty for violations is up to 250,000 euros, and for natural persons also imprisonment of up to 2 years is possible.
Then we come to Luxembourg. Luxembourg has not yet transposed the directive to national law, but has a draft bill published in January. The draft law largely follows the directive. The anonymous reporting is permitted, email reporting is permitted. Small businesses also in Luxembourg need to implement the whistleblowing system not before December 2023, so have more time. But in Luxembourg, it is expected that the implementation of the whistleblowing system will be assessed by an authority. Then we come to the next slide, please.
In Poland, a law bill was published in October last year. According to this, legal entities might amend additional reporting topics to other violations of national law and or internal regulations and ethical standards. The anonymous reporting and the reporting by email should not be prohibited, and companies with 50 to 249 employees will not have to implement a whistleblowing system until December next year. And penalties for violations are according to the Polish Criminal Court, and for natural persons, imprisonment up to 3 years is possible.
Then we come to Romania. Romania has not transposed international law yet, but has published a draft bill in November last year. The implementation is not expected in this quarter. We have no information when it will be transposed. But however, it is expected, according to the draft bill, that the law will provide for report of additional topics as violation of national law. The anonymous reporting is permitted. The email reporting might be prohibited, according to our information we received yet. So we will have to wait for the law, for the final version of the law. But by now, it's expected that email reporting will not be permitted and will be prohibited. The fine for violation is up to 10,000 euros for legal entities, and for natural persons up to 300 euros. And then we come to the next slide, please.
And in Slovakia, the draft law has not yet been passed by the parliament. The transposition is expected by May of this year. And in addition to the reporting topics of the directive, violation of national law will also be possible as an additional reporting topic. Until the transposition, the directive shall be directly applicable to state legal entities, departments, and other public corporations. And anonymous reporting should not be prohibited, and violations can be fined up to 20,000 euros.
In Slovenia, the directive is also not transposed yet to national law, but a draft bill has been published in December last year. The implementation is expected in the next quarter, so until end of June 2022. Pursuant to the draft bill, the anonymous reporting is not prohibited, which means it's not mentioned. The email reporting is not prohibited. Small businesses up to 249 employees are obliged to implement a whistleblowing system not before December 2023, and the fine for any violation amounts up to 6,000 euros. And then we come to the next slide, please.
In Spain, a draft law already exists. Until the transposition, the directive should be directly applicable to state legal entities, departments, and other public corporations. The issuing of hints by email should not be prohibited, and penalties for violations should be fined up to 1 million euro.
In the Netherlands, the whistleblowing directive is not yet transposed to national law, but a draft bill has been published last year, already in June. However, the Netherlands already have a national law under which small businesses are required to have a procedure for the internal reporting of suspicious misconduct. The directive is seen as directly applicable by now already, as the transposition period has expired. Under the draft law, according to the draft law, the anonymous reporting is not prohibited, and email reporting is not prohibited, and small businesses up to 249 employees will have a later implementation date, which is in December 2023. And then we come to the next slide, please.
Thank you. Finally, we would like to briefly introduce you to the countries, including Germany, which have so far not transposed the directive or published a draft. In Bulgaria, the Czech Republic, and Greece, the first drafts are expected at the end of the first and during the second quarter of this year. And by the way, in the meantime, infringement proceedings have been initiated against Bulgaria. And regarding Germany, Mr. Federmann will give you a brief overview.
Yes, thank you, Andreas. We have had already a draft law in 2020. However, according to the principle of discontinuation with the new parliament and the new government in Germany, this does not exist anymore. And at the moment, we have new law under construction. The competent ministries are in alignment in this regard, and it will go through governmental initiation in the Parliament. So the Chancellor and the ministers will have it in the next or the overnext session to have a review and then give it to Parliament and then goes through the Parliament. That is at the moment the stage. And we expect that in Q2, that means April onwards, up to June, it will be also transposed in Germany. What we know at the moment, that not just European law, however, also national law, criminal law, and so on will also be covered by this new law that is meant more than it is demanded by European Union. That's for Germany at the moment.
Okay, and then we come to the last slide, please, for this section. It's a short overview, a short introduction into Hungary and Italy. Hungary and Italy have not yet transposed to national law and have no draft bill published yet. However, Hungary has already, Hungary and Italy, both countries already have law applicable, which includes provisions on whistleblowing procedures. In Hungary, under the current applicable law, anonymous reporting is permitted and email reporting is permitted, so it's expected to remain the status. The directive is not seen as directly applicable to state legal countries in Hungary, as well as in Italy. And Italy has already currently 5 laws applicable, which include provisions on the whistleblowing procedures. So this is, was the short introduction, short overview to the transposition status of the whistleblowing directive to the EU member states. And now I hand over to our colleagues for a detailed presentation.
So hello also from Austria on this sunny day. My name is Susanne Flöckner. I'm the responsible partner for compliance, risk and forensics with KPMG Austria in Vienna. Well, regarding whistleblowing, I'm responsible for and supporting companies for setting up, implementing whistleblower systems, running them, following up on reports received, and also with investigations if necessary. So I'm looking forward to giving you a short overview of the actual status in Austria, although it's not rather far because we also don't have a national law. So the directives have not yet been transposed in Austria, and there is also not really an official draft bill for the so-called whistleblowing Gesetz in Austria. There, at the end of January, because of that, the European Commission decided to initiate an infringement proceeding against Austria for failure to transpose this directive in due time. We had a call with the responsible federal minister a few weeks ago in Austria, and he told us that we can expect the implementation by the end of June 2022. So far, there's nothing new, but there is an existing work paper dated with October 21. It's just a draft, which still has some topics to be defined. For example, the possibility to place anonymous reports. So it's not yet been decided whether the Austrian whistleblowing law will cover anonymous reports or not. But with regard to the design of the internal reporting channel, this working paper doesn't provide for specific requirements. So it states that the channels must allow for either written or oral reports or both, and that the whistleblower must be granted the possibility of a personal meeting if desired. What is also open, not defined yet, is the scope of maybe additional reporting topics, for example, corruption. Another thing that's open is the responsibility for the external reporting system in Austria, which means that the institution that will serve as the general external reporting channel hasn't been decided yet. However, the existing external reporting channels like the Austrian Financial Market Authority and those of the Financial Intelligence Unit for money laundering reports will remain in place alongside with the new general external reporting channel. So overall, according to this existing work paper, which is, as I said, draft, it appears that the Austrian working whistleblowing law will largely follow the regulation of the EU directive. For example, of course, the obligation to implement the reporting channels for private and public companies with more than 50 employees. There will be a delayed deadline for small companies, expected to be December 2023. And companies with fewer than 250 employees may delegate the internal reporting channel to a joint unit or to an entrusted third party, a consulting or law firm, as long as this unit or this entrusted party has registered offices in Austria. So group companies with 250 employees or more must implement their own internal channel. However, the group may use a common whistleblowing system, but as long as the access and processing of reports per unit and company are strictly separated. The national working paper doesn't provide any exemption for communities with less than 10,000 inhabitants, but in Austria, this exemption must be included in state law units of our 9 different provinces in Austria. So we expect that these corresponding exemptions for the communities will be placed. There are also several protection measures foreseen in the working paper for whistleblowers, given that the report is justified and within the scope. So the protection against retaliation, such as termination of the employment or contract, denial of promotion, reduction of wage, disciplinary measures, and there's also protection for release from liability, and there's the reversal of burden of proof foreseen in the working paper. So whistleblowers who knowingly make a false or misleading statement are not protected, as is also stated in the directive. This working paper also contains a separate section of data protection issues. They clearly rule that only the permissibility of processing data when operating a whistleblowing system, and it's not permitted to pass on this personal data from the whistleblower system within a group. There is no specific, or there's not a specific termination or regulation on the participation rights of employee representative bodies, like as work councils. But however, we do not expect that they will need any approval from work councils to implement a whistleblowing system. So overall, it can be said that although we should have already implemented a national law by the end of December 2021, the Austrian legislator has not yet defined an official draft law, and it's still some questions are open. We are looking forward to receiving some updates soon, but well, at the end of March, nothing new on this side. So this was the overview from Austria, and I will hand over to my colleague who will proceed. Thank you very much.
Please flip the slide, please. So, hello everybody. My name is Christian Møllegaard. I'm the head of whistleblowing services in Copenhagen, Denmark. So, in Denmark, we have already implemented the whistleblowing directive into national law. So I have made a table in the top of the slide to make sure that you can see when the implementation is actually happening. So for private entities with more than 250 plus employees, this is already implemented by the end of 2021. So this actually is already happening. For smaller private entities with employees from 50 to 249. This will only first be implemented at the end of December 23. So we have some more time to actually get this implemented. The main content requirements for the whistleblowing scheme is, I have listed some of the main things below. So this is like the identity of the whistleblower and other persons included in the reporting must be kept confidential. This also means that the whistleblower should be able to keep confidential also for the company. This might not be an issue if you want to proceed with the reporting. So the whistleblower might need to come forward, but it's up to the whistleblower himself to actually come forward. This also means that retaliatory measures against the whistleblower is prohibited if the person wants to come forward. So the person should be treated identical to other employees afterwards. This also means that the employer must set up an impartial whistleblower unit to administrate the whistleblower scheme, which means that the impartial whistleblower should be not affected by the reporting and should be kept objective to assess the reporting. This also means that the whistleblower is obligated to receive feedback confirmation from actually the reporting within 7 days, and information on any follow-up action on the reporting. And this is also due within 3 months after the confirmation of the reporting. Then to make sure that this is happening in accordance with the law, the company needs to set up and prepare policies and procedures to actually document the proceedings of the reporting. This also means that the whistleblower challenge must be available for all employees in the company and not only a few. And as extra information, I have added a few interesting topics that could be relevant for you guys. So even though the whistleblower channel must only be available for all employees, it could also be made available for other stakeholders as business partners, suppliers, clients, and etc. This do not mean that they cannot report against you. It would just be reported in a public provided whistleblowing scheme. So it might be strategically relevant to make this available for all stakeholders to make sure that you have full control of all reportings against your company. The employer can also make this impartial whistleblowing unit outsourced partly or fully to other service providers such as lawyers and auditors. This is where KPMG and our services come in play, where we can help you administrate and kind of like keep you compliant with the rulings. Further, I've promised to make sure that you can also make reportings through email and phone calls, but this is not a requirement, it's just an option for you to take advantage of. And as an extra note here, you can also group your whistleblowing system, so you don't have to set up one for each of your entities with 250 plus employees. You can actually set up one centralized whistleblowing scheme for the entire group. This is also allowed in accordance to Danish law. So this is a short and crisp introduction to the Danish law, and that's all I have. So please flip the slide to the next presenter.
Thank you. Greetings from sunny Finland. I'm Antti Aalto. I'm heading the Legal Compliance Department of KPMG in Finland. And as to the agenda, I have actually 18 points to go through today. First 6 points are of general nature and background. Then again, 6 points on actually evaluating the national draft legislation against the targets set in the directive. And then the last 6 bullets go into the nitty-gritty details of how expensive and complicated an implementation can be. To get started, Finland has been implementing for its clients, employing people from 20 to 40,000 on a global basis since 2020. So we have a fair bit of practical experience on how to deal with the directive and lack of national law regulating the manner. So firstly, the Finnish draft law was published in July last year, and it attracted a lot of comments from industry players, especially, and the critique was targeted toward the anticipated or perceived complicated process requirements set forth in the law and in the directive. And this might have a bearing on the draft law that is supposed to be introduced actually next week in the Parliament, and is to be dealt with by the end of July according to the current time plan. In the meantime, Finnish government has instructed employers already in 2020 to implement the systems and organizations in accordance with the directive, and not to wait for the national transposition of the directive. And this has, of course, resulted in a medium or nice amount of activity in actually getting the systems in place. Finland, as such, did not have a whistleblower legislation prior to the directive, which is acknowledged as you perceive as primary legislation over the national one. We only had the on market abuse regulation based requirement for public companies to have a channel without any qualitative requirements whatsoever. And this basically has resulted in Finnish public companies having even an email system in place, which, according to current understanding, is not allowed under the GDPR regulation for the purposes of whistleblower directive. So, as to the comparison to the directive set targets. The directive as such is considered as protective towards the potential whistleblower. There, in the draft law and in what we expect is that national laws might have deviations, including the Finnish deviations, that rise the cost of implementation for multinational employers and the process of actually dealing with the whistleblower reports. The national legislation is reasonably protective based on the fact that the Finnish national law on companies allocates the liabilities to the top management of the company or the employer in a manner that they have a reverse burden of proof of as to how and whether they have information and have made sufficient inquiries as to how the company's business is conducted. And the whistleblower system, when properly construed, is just about perfect a tool to call in reports on wrongdoings. And hence, the law can be interpreted as requiring the implementation of the system in accordance with directive and the allowance of the usage of the whistleblower system to also other transgressions than those that are stated in the directive. So anything from misdemeanor against the company code of conduct, against national law or regulation, all the way to the regulations stated in the directive. Protection against retaliatory legal proceedings is in the draft law astoundingly strong. Those can be brushed off basically with the claim or statement that this might be a retaliatory process, so to dismiss a whistleblower or to otherwise harm his or her interests, and the court of law would then be liable to set the case aside or even reject that without further investigation into the case. So in that sense, the law is fairly protective. The one interesting issue is, as it stands in the draft, the damages liability of employer towards the the whistleblower is capped in accordance with Finnish labor law, which basically sets out the cap at 24 months salary. And that is probably not entirely in line with what is meant in the directive. However, there is a soft compensational clause on top of the cap limitation, which is at this stage a bit vague, but might be instrumental in actually making the Finnish law draft being compliant with the directive. On the anonymity of the reporting, so employers on the private sector are required to accept anonymous reporting and arrange for the dealing and enriching investigation thereof. The public channel, however, at this draft stage, would allow only reports with identity attached to them. It's feasible that I'd say a deviation from directive principle would remain in even the draft law or the government's proposal, but we'll probably see and be more wise next week, hopefully, as to whether there's a change of wind. Finland has, as it stands, already a public reporting channel via the Office of Chancellor of Justice. However, that is not on the face of it very secure, nor is it anonymous. So in that sense, there might be an issue for any major employer whose own channel is likewise in need of a bit of brushing upwards. The penalties for less than appropriate implementation of the directive and whistleblowing system are indirect. As I mentioned, the Finnish National Companies Act and even Foundations Act impose a reversed burden of proof to those charged with the governance of the employer, and the details go in sufficient depth to make it viable to understand the legislation, as if the board does not see fit to find out through whistleblowing channel what's going on in the operations, it has not fulfilled its duty of keeping tabs on the operations, and hence would be deprived of discharge from liability at the end of the accounting year. So that is a fairly distinct method. I think we have a bit similar approach as Denmark has on this one. But the thing that might be criticized in this circumstance is that no penalties for non-implementation or non-conformity with the requirements has been imposed or proposed at this stage. They were discussed during the early days of legislative process, but so far they have not been appearing in the drafts. Then, as to the niceties and details, I'd like to highlight as compared to the directive. First of all, utilization of centralized system is not prohibited, and I believe that it will not be prohibited. However, the Finnish national law on privacy in work life and few other regulations put a fairly stringent quality and duty of care requirement for centralized systems, especially as does actually GDPR and labor law. So you need to have that claim in your head as with a large pinch of salt, so that saying that it's not prohibited doesn't say it is allowed. There are some additional covenants there. one of the things that appears to be very neatly protected in the Finnish approach is that the employer management does have the added benefit of actually controlling the suspicion data, so the whistleblowers that are flowing as regards the company. So it's the employer takes on the cost of running and building an appropriate system, communicating it appropriately, and then the management may rely on the fact that it does have sufficient interest and information as to whether or not the employer business is run in accordance with relevant regulations. And that is basically a rather valuable asset. It's a supremacy of information, and there are very, very few things in the world, in my opinion, that are more valuable than having better information than the other players on the market. A Finnish speciality, additional liability allocation to the person or entity making a decision on implementation and acquisition of a whistleblower system. So the proposal states that basically the person or the body making the acquisition decision needs to make sure that the system and process are appropriate and in accordance with the relevant regulation. And if that is not the case, the decision-making body will be charged. And we have a few, in Finnish terms, quite large companies, large employers as our customers on this topic. And one of those spent over 3 months on exclusively the technical capabilities and the compliance of the system. So 3 months before starting the implementation. And then the implementation did take a bit of time, but then again, you would expect that. So there's, should I say, a liability for duty of care, and that's I haven't seen at that level in the Directive. So it's a third liability level there. There are other legal considerations I'd like to bring up. First of all, the cooperation with employees. The Cooperation Act was just on the 1st of January renewed, and basically the process of having the system and the policy of whistleblowing accepted by the employees or employee representatives is considered fundamental in having the whistleblowing policy in place as a almost contractual clause in everyone's employment contract. And that is, of course, important for the fact that each and every employee is aware and understands that if they have a concern on how the company's business is conducted, they are free and are encouraged to announce their concerns in the company's own channel and are not allowed until the 3 months investigation period is run out to go to other medias or even to the public channel with their concerns. So again, supremacy of information. Then the whistleblower policy, in which the employer can, in further detail, set out how and by whom, when the channel is used, what is done. Intergroup agreement, I think that was referred to as to a GDPR tool, but there's more to that. But basically, without the intergroup agreement, the personal data containing suspicions and whatnot is not to be transferred from one country to the other or in between companies. So there needs to be a legal ground for handling of personal sensitive data. In Finland, the standing practice is that systems like this need to undergo data privacy impact assessment in accordance with GDPR, and that's a very sort of standardized procedure. It does, however, take a bit of time and effort, as that needs to reflect, of course, the chosen setup, the chosen configuration of the system and the process. And then again, a GDPR-related issue, the whistleblower policy statement, privacy policy statement, needs to be coined to actually allow for the confidential handling of the personal information, and to maybe cut off the data subject's right to the scrutiny of information on him or her. So a bit of tooling going on there in legal and administrative terms. One of the difficult things that our customers have paid attention to is basically independence and credibility, and how to communicate that in the sense of the directive. So how do you communicate to your general employee group that yes, we have a solid system, we have a solid process, and you may place reliance on your anonymity and your concerns being dealt with due care as set out in the directive. And one of the items that has been bugging our customers is that even though you may be able to set up internal independent, and that is a legal requirement, independent whistleblowing resolution body by a charter, basically. A charter is rather cumbersome and difficult to communicate understandably to a large amount of staff. That yes, there is sort of a governance within governance in the company for whistleblowing systems, and the whistleblower governance is independent from that leading the business of the company. So for that purpose, we've found that it is far easier to convincingly communicate that the processing is actually done by, for example, KPMG, thank you very much, or other external party that carries a liability of confidentiality and care as chartered accountants in general do carry. I have one concern, major concern, as regards the Finnish public channel, and basically the Finnish public channel at this stage is not up to par with the directive requirements. And from the whistleblowers or potential whistleblowers point of view, this means that if your employer's system is not up to par, so up to requirements, and the public system is not up to requirements, you're basically allowed to go to the media or even social media with your concerns and state them to the press prior to actually expressing them to the management of the company in fear of retaliation or otherwise. And then again, that would lead to the fact that the information is leaked out of the company management cannot do anything about the proposed wrongdoing, can't control it, can't correct it, and the information is out, and the investigations by media or authorities might begin. And at the end of that game is the fact that you lose a lot of money, market, and fame in such a process. We've helped a few companies in actually improving their systems after those incidents. And basically, you are not in charge at that time. And I've had yet to meet a director or manager of an employer who would not rather have their sort of dirty laundry washed in private so far as possible, as compared to the fact that in few cases it has been watched in national media. And that is a thought I'd like to leave you with and hand over to our French colleagues, who undoubtedly have their own special give on the transposition. Thank you.
Thank you very much. Good morning, everyone. I'm Julie Belser, come from KPMG Avocat in France, in Paris. I'm partner in compliance department and specialize on the compliance and anti-corruption and data protection matters. So, in France, there has been a whistleblowing system since 2016. It was introduced by the Sapin II law that covers both whistleblowing and anti-corruption program. it concerns all public or private companies over 50 employees, all cities with more 10,000 inhabitants, and public administrations who must set up a whistleblowing system. Whistleblowers are protected by the law. However, they must follow a certain protocol. First, they must use the internal reporting channel. Then, if the alert is not proceed within a reasonable period of time, they may submit an external alert before judicial authority, administrative authority, or professional orders. And finally, as a last resort, they can proceed to a public disclosure. The law transposing the EU Directive was first introduced by a French MP on July 21st, 2021. After several months of discussion, the final version of the law was voted by the French Parliament on February 16th, 2022. The Constitutional Council was seized to control its compliance with our Constitution, and last Friday, the Council considered that the law is mostly in compliance with the Constitution. The news that the new law was enacted 2 days ago in France, so the 22nd March. And now each company have to be compliant in 6 months. So our new law gives companies 6 months to be compliant. So 22nd September. So in France, the directive is completely transposed, but we are waiting for some decrees. We didn't use the possibility to offer additional time for smallest companies with 15 to 249 employees. The new law is applied to all public or private entities with more than 15 employees, cities with more than 10,000 inhabitants, and public administration. So the same for us and no change for a French company. The new law will come into force in September, you understand. What are the key takeaways? First, no more cascading report system. The whistleblower may either use the internal whistleblowing system or the competent external authority. Only public disclosure is still subject to certain conditions. Second, we have an extension of the scope of violations. Violations don't need to qualify as serious or obvious anymore. All violations may now be reported. Then, we have an improvement of the whistleblower protection. The law provides more prohibited retaliation measures in the workplace, for example, reputational damage in a social media. Extension of the exemption from criminal responsibility for the whistleblower, establishment of an exemption from civil responsibility. Plus, there is a civil fine for dilatory or abusive practice is double, so 6,000 euros. And persons who discriminate against a whistleblower may be subject to a fine of 45,000 euros. There is the protection of the whistleblower is extended with the new law. Extension of the whistleblower protection regime is extended to third parties such as colleagues, family members, or facilitators. Please note that in France, the facilitators is any natural person as the EU directive, but it's always to any private, not-for-profit legal person who helps a whistleblower. Therefore, trade unions or associations could be qualified as facilitators. As provided by the EU directive, only companies with less than 250 employees could join their procedures for collecting and processing reports. Regarding groups, the whistleblowing systems may be common to several or to all companies in a group. No thresholds regarding the number of employees are specified to proceed with this mutualization. It will therefore be possible regardless the number of employees of the French subsidiaries. But a future decree of the Council of State will determine the condition of the procedure within groups and how information related to a report may be shared within a group. So at this stage, it cannot be excluded that this decree will limit the scope of the mutualization for groups. Please note that there is no sanction for not implementing a whistleblowing system in France. However, the fact that whistleblowers may choose either to submit reports externally or internally may increase the number of external reports and lead to reputational risk for companies. So we advise you to set up a whistleblowing system in France, even if there is no sanction. And if you already have one, you have to adapt it to the new law. Thank you.
Hello, everyone. My name is Michelle Johnson. I am a manager at KPMG Sweden and part of our GRC practice. I am a lawyer and I specialize in business ethics and I lead large compliance-driven projects for us, mainly in the corporate and public sector. I will do my best here to give you a bit of an overview of where Sweden stands in the transposition. As a typical lawyer, there are slides with lots of text, but I will try to point out the most important differences, both from perhaps the European legal perspective, but also from the previous whistleblower protection in Sweden compared to the current situation. So Sweden is one of the 5 countries who have transposed the whistleblowing directive into national law. There is a new whistleblowing act, Whistleblowerlag, and it entered into force on December 17th, 2021. That means that companies should already have started their process to be in line. However, there was some more time for applicable parties to set up their internal reporting channel. So this is done in 2 steps. So by July 17th this year, public entities, regardless of size, and private entities with 250 employees or more need to have set up their internal reporting channels. And by December 17th, 2023, all private entities with more than 50 and up to 249 employees will have to set up their internal reporting channel. So this new Whistleblowing Act replaced the former Whistleblowing Act. It was deemed in the pre-works to the new act that the former version did not fully live up to the standards set in the directive. The main differences is that now, under the new Whistleblowing Act, in line with the directive, there is a wider circle of persons covered by the protection. The threshold of what you can report is lowered, at least in definition, from serious misconduct to misconduct of public interest. The material difference here remains to be seen in interpretation in court. The protection in the form of discharge of responsibility was also added. That means that you can, in certain circumstances, go beyond your NDA or your confidentiality agreements, and you will not be punished for it. But there are exceptions, especially when it comes to national defense or medical professions, etc. There is now an obligation to set up an internal reporting channel, which is a difference for certain operators compared to the previous law. And there is a new division of external reporting channels for certain authorities. There's a whole list of authorities that now have to responsibility to take care of external reporting channels. And there's also new provisions of the processing of personal data. We can go to the next slide, please. So as I mentioned here in the previous slide, that's mainly the difference between the previous legal situation in Sweden compared to now. Are there any differences from a Swedish perspective compared to the directive? Here we've seen that the legal text in the transposition into Swedish law, we say public interest. It must be a misconduct of public interest. This is taking it a bit further than the article text in the directive, but it's in line with the preamble and the pre-works, with the main aim of ensuring protection for those who lift up misconduct or bad behavior that is of a public interest, so going further than breaching legal obligations. For something to be of public interest or allmänintresse, it must concern a circle of people who can be described as the public. It's not applicable if it's only regarding myself, for example, but there are special cases. You can actually report on something that is affecting you personally and not of a general public interest if it has to do with slave-like conditions or a systemical violation of legislation. You cannot report using the whistleblowing channels and have the protection that incurs if it has to do with security classified national security and defense related information. This is something that was left up to the member states to decide upon. And here Sweden has taken the stance that you should not use this channel for these types of information. Otherwise, it's very much in line with the directive. You can not take preventive measures, and the interpretation here goes as far as even if you make it difficult for someone to report, that could be seen as a preventive measure. For example, you don't post it properly on your internet and you don't make it easy for someone to inform. If you violate any of the prohibitions, you are liable to pay damages, and it can be financial damages or non-pecuniary damages. It's similar to in Finland, where it's a gradual scale and there's a cap on financial damages related to how long you were employed, for example. And non-pecuniary damages can mean, for example, if you were dismissed as a result of your whistleblowing, that can become voided, so you would keep your employment. The amounts will remain to be seen, but it will be in line with the protection under the Employment Protection Act. So other breaches of employment law will guide you in terms of how much sanctions will be afforded to you as a whistleblower who were then retaliated against. What can be seen as a retaliation? There you can see guidance from the Discrimination Act, for example. Okay, I think that we should move to the next slide. The special requirements for setting up a reporting system is very much in line with what has been said with previous speakers. Something that I think is important and interesting to point out is that in Sweden, you have an obligation to also receive anonymous reporting. You need to be able to receive reporting via phone lines and within a reasonable time also a personal meeting. But otherwise, we've kept in line with the directive. You can divide the tasks, you can outsource the tasks, but it must remain independent and autonomous. And I think the last two parts on this slide we've gone through. Something I want to point out maybe from the previous slide is that we have divided the responsibility of the external reporting, depending on which topic it's about, on several different institutions in Sweden. And we can go to the next slide. So to wrap up, because we've gone over retaliation, we've gone over now that it's an additional personal scope, it's not only employees, it's a much wider scope of people concerned, and it can also be before you're employed and after you've stopped working at your employer that you would be afforded a whistleblower protection. Important to note here that the Swedish Work Environment Authority has been established as the overseeing authority. This is a new role for them, and it remains to be seen how they will and if they will fine practitioners and entities for not implementing a whistleblowing system. Another point that's interesting to point out is that all public entities have to have a whistleblowing system, but they can share them. So, for example, within a municipality, you can have one channel, internal channel for all entities. And the question that has been raised by several colleagues on bigger entity groups with more than 250 employees, this is being very much discussed with our clients also, if they can somehow continue having a centralized channel. So interesting times ahead. Thank you very much for listening, and let's move on.
So, thank you very much for your contributions to all the speakers from KPMG. I hope this was really interesting for the audience, and just looking at all the questions that were asked here in the chat, my impression is that it's very interesting, and that you learned quite a lot, but still quite some questions open. So we will definitely take time for a short Q&A session. Still, originally from the agenda, we had planned that we would also spend some time on introducing the EQS whistleblowing solutions that we provide. We will skip this for now. Just let me say that clearly, because we are doing this for many, many years, and being the European market leader in whistleblowing and compliance software solutions, you can fully rely on the solutions that you either already have in place or consider to probably buy and introduce from us, will allow you to be compliant with the directive in each of the countries, because these solutions allow all the flexibility that you need to comply with the directive itself, but also specifics on a country-by-country level. So if you're interested to find out more about this, either you can take a look at the slides. We will share the slides that we thought we would present today with you afterwards on request, and yeah, just get in touch with either our sales colleagues or our customer success colleagues if you want to discuss in more detail on how to do certain things. So having said this, I would actually propose that we just directly move over to questions. And from the many questions that we've received, I've tried to group them a little bit, and so I will just ask some of the questions to the experts from KPMG, so that we can see if we can get some answers at least for you at this point. So maybe Bernd, if I may address you, and feel free to then assign a question to any of your colleagues if you think so. Let's start with a short one, a simple one. The question was coming up. What about written reporting, oral reporting, or both? So what is actually the obligation from the directive and the transpositions?
Yeah, thank you very much. Very important topic throughout the whole European Union, as it was a deep discussion with the Danish bill together with the EU Commission in summer last year. And the Commission published several documents where it stated that we have to have a decentralized solution. They come from the view that the law is to protect the whistleblower so that he is able and motivated to report violations, in particular for break of European law. So we want to have a local access of the whistleblower to his hotline and to the people doing the case management. That is the background of this approach. So we have discussed several topics in the EU directive and it is the question on how it is transposed then to the into the national laws. However, one is to say centralized channel is always allowed when there are local channels also foreseen. So important to say, and that is also the position of the European Commission, it is always allowed to have a central channel. However, also the necessity to provide the possibility for local access. That is the one thing. And then the other question is how to organize. And there is a main question. Many of the big companies who have already implemented systems do it centralized. So they have the forces in the central headquarters, and according to this, what is necessary be done with regard to the motivation of the whistleblower and what can be assisted via the centralized organization, the central organization, that is the real question. And we are of the opinion that through service level agreements, certain aspects can be done centrally when provided local. So the resources of the central may also be used in line with the EU directive when organized it in a proper way. That is the position at the moment. And then it's very interesting to have, perhaps in this respect, to have a look with the single member states who have already implemented, like France, like Sweden, as we heard. Perhaps the colleagues from France and Sweden or Denmark may go in depth how the discussion in this respect is made with your clients so far. So perhaps Sweden, would you want to start?
Of course. So I work a lot with automotive sector clients that are quite large, and they are having this discussion of having on the front end perhaps different channels locally in their entities, but on the back end still having this centralized approach to divide the task, to make sure that the investigation takes place at the right level in the company, etc. And I think this is something that we see in many of our client discussions with helping them to set up their whistleblowing channels and also setting up technical solutions for them. This is where we see that the discussion is going. It remains to be seen if the authority that now has the right to oversee this will accept this line of reasoning, but I think it would, in my interpretation, be in line with what the aim of the directive is, and in line with what would be appropriate for companies with more than 250 employees or thousands.
All right. Thank you very much for this. So if I hope everybody agrees that we probably try to address one more question. And so one question that was asked was about employee participation via employee representatives. So this is just for clarity. What exactly does this mean? Is this related to involving employee representatives mandatorily already in the selection of a whistleblowing solution, a whistleblowing channel?
This might perhaps be handed over to our labor law experts. Andreas or Ariane, could you take over?
Julie speaking from France. For representative employees in France, we have to inform and consult them before to set up the whistleblowing system. It's very important. It's an obligation for French companies.
Thank you, Julie. And maybe I can add from an EQS perspective. So as a provider, where we implement with and for customers in many different countries, involvement of employee representatives when implementing a whistleblowing solution makes perfect sense. This is our experience. So in some countries, it's a legal obligation. In some other countries, it probably isn't, but it's definitely good practice, because this has also to do with trust and with the employees' representatives, worker council, and so on, supporting the implementation of such a system, because then we also see usage of these systems. All right. There was one more question that we can probably take. The question that was asked, if a whistleblowing system would also be opened to third parties, so to business partners or any externals, would that mean that in this case, whistleblowers from these external parties must report through this channel when they report any misconduct related to the organization, or are they still allowed to pick and choose and say, I either use this or maybe a public authority reporting channel? Anyone who can say something here, answer this one?
Antti Aalto from KPMG Finland. We have experience with a company or group of companies that actually opened up its whistleblower channel directly to the supply chain and the physical environment in which it operates, as it runs a business that is viable of causing environmental damage. Let's put it that way. So what is the whether or not you can obligate your external would-be whistleblowers to use the internal channel, that is a contractual setup that needs to be put in place in regards of the supply chain. And for that, the directive as such puts some limitations. So a modicum of judicial finesse in contract negotiations is required to actually establish that. As regards parties that are not contractually bound to that employer setting up their own system, the directive, nor at least in Finland, the national law, does not provide for a mechanism that would empower the employer to actually bind other parties who are not in contractual relationship with the company. So in general, the more public you want to go and the more information you want to have for your internal purposes, the more sort of open and wide-reaching you should plan your communication plan. And in this one instance, they basically even used the local media and local newspapers to announce, okay, you live nearby our plant. If you see anything, call us. We are here to do a good job and not a bad job. We want to know if something is going wrong. I think that was greeted with much joy in the environment, and even has resulted in some suspected breach reports coming in from those who are not bound to the company's own system.
Thank you for this input, Antti. I can maybe add that our experience is that around about 95+% of all our customers, and these are really many, are opening up such systems to both internal as well as external whistleblowers. So it's definitely best practice. And as Antti also said, if you implement such a system, you want to know what's going wrong in the organization so that you can mitigate. All right. So with regards to the time, I would actually think we need to stop. We are already 5 minutes over. And I think many of you might be running out of time and have other meetings ahead. So thank you very much, first of all, for participating. And thanks once again to the speakers for the really interesting contribution. We will follow up on the questions that were left open and not yet answered. Anyhow, at any time, please feel free to reach out to either our colleagues from KPMG or to us, and we will try that we find the answers for you and give the answers. And I would like to also announce already that we will be having a second part of this webcast on the 5th of May. So stay tuned, invitation will follow. And we see many of you again in a few weeks' time. So stay safe and healthy. Have a great day. Thanks, everybody, and bye-bye.